So thank you everyone again. Thank you for the introduction. So I will focus on the LATAM case, so on the Latin America countries that I know for my role of global litigator, and also because I've been formerly the general counsel for always for the Atos group for Iberia and Latin America. So I try to give, first of all, a definition of the three main alternative methods of dispute resolution in respect to the traditional litigation. And I tried, among the several definitions that you can find, or that the several ideas that you can have, the one that, let's say, match better with the LATAM culture. So about conciliation, as you know, it's a method that is chosen by the parties on a voluntary basis, where basically there is a potential dispute, or there is a dispute, and normally the parties, this is the way it is interpreted in LATAM, do not have a strong and consolidated relationship. Then, of course, there is conciliation in family right so between in a marriage or for family right reason in connection with the assets, etc. But when we talk about companies, conciliation is normally a voluntary process which is even not provided in a contract, that the parties try to explore when they want to find an alternative solution, and they want to have someone that is not imposing a solution, but is trying to negotiate with them a solution, that doesn't have the power to issue a judgment or an interim measure, but of course has the power to persuade the parties to find the best solution for everyone. Then we have mediation. Mediation that, after the European Union directive is working also more or less in certain European countries, especially in the West, but is not yet there. So mediation, again, is another mechanism based on voluntary willing of the parties not to go to a fight in front of a tribunal, but to have, a sort of consensus around a common interest solution, where a mediator is someone that is able to, first of all, narrow the discussion, understand what are the interests at stake, and find a mutual acceptable solution. So then we will see that also in the LATAM countries, as it happens in certain European countries, mediation is a compulsory step if you then want to go to litigation, which is a quite clever manner to reduce the number of litigation that are filed in front of the tribunal, because the parties, this is the ration, have to explore any alternative before going to court and before inflating the court with other claims, and that at the end of the day will delay the whole process on issuing a judgment. Then we have the arbitration, which is considered still today the more important alternative to the traditional litigation, so to the tribunals. Again, here the mechanism is much more institutional. You have, depending on the kind of arbitration rules, procedures, the arbitration body has the power to issue interim relief sometimes, will issue award that will have the same value of a judgment in a traditional tribunal. But what is different is that an arbitration, in order to be triggered, again, must require the consensus of the parties, and so there must be a normally well-written, or what is supposed to be well-written arbitration clause in the agreement, which allow the parties or the party that is more interested to raise the arbitration. Then you can see here this interesting table, that chart that shows how is that LATAM countries with recent regulation finally tried to explore alternative dispute mechanism. Because if you see the chart, this is the average time in days in order to obtain a first instance judgment. So you can see that in Brazil, you must wait for 2,200 days, almost 7 years and a half, to obtain a first degree judgment. And then you have to go through, if of course this is not satisfactory for the parties who lose, to the 3 traditional degrees. So you have 2 more steps. And the best case is Argentina, that let's say has better timing. It's less than half, but it's still 1,000 days. So you can understand that whenever, and I'm thinking especially to Brazil, you have a huge number of litigation, especially for labor matters, or I'm also thinking to fiscal matters. And the problem in Brazil is that whenever you are litigating against the state and for fiscal reason, in order not to suffer the enforcement of the a decision that has been issued at an administrative level, you have to put on the table a bank guarantee which is equal to the value of the claim at stake. So let's imagine that you have in Brazil a litigation, a fiscal litigation for 100 million euros, so the equivalent in reais, the local currency. You have to grant your debt by putting a bank guarantee on the table of the same amount for a litigation that risks to last for 10 years, whose cost is between 2 and 5%, just the cost, without thinking to the risk. The cost of maintaining alive a bank guarantee is from 2 to 5% of the whole amount, plus interest, plus inflation. So you will double the amount of the debt in 4 years' time, with the level of inflation and of the valuation of the currency that Brazil is experiencing nowadays. So, as you may understand, when you are a multinational, and we almost all we belong to multinational, or we have law firms working with them, and you want to secure your investment, you want to find an alternative to the traditional litigation, because it's going to kill the accounts of any company, either for this cost, this huge cost of the litigation, for the cost of maintaining alive a bank guarantee, and also for the cost of having to put a provision in your accounts based on prudential criteria as the accounting principles want. You can see that now that the Latin countries have implemented some ADR methods that are quite, let's say, more reliable than in the past, the average time frame is between 90 and 180 days. So there is a huge difference between traditional litigation and these alternative methods. Of course, let's talk about Argentina. Argentina is a complicated country for the ones that you know it, with a big political turbulence, with also huge turbulence in terms of labor rights. As many countries that come from past made by dictatorship, there is also a huge protection that is granted to the employees. So there is a huge number of litigation, especially for labor. In this case, there are alternative methods such as the mediation that, as I was saying before, is mandatory unless the national government is a party of this potential fight. Why? Because, of course, many of the rights and interests at stake cannot be subject to mediation or settlement as per the Argentinian law. The mediation is carried out by a licensed mediator who hasn't to be necessarily a lawyer, while this is the case for other jurisdictions, as we will see. And as usual for any mediation, it's confidential, not subject to particular formalities. And at the end of the day, if the parties agree on a solution, this will have the same effect of a final judgment and can be enforced and will be enforced in front of the Argentinian courts. Then, as you can see, regarding, let's say, the arbitration, there is a very recent regulation that just entered into force last year, where the Argentinian legislators tried to catch all the best existing on the market, let's say in terms of arbitration principle. For instance, the principle of competence. What does it mean? Is that it's the same arbitration body, the one that will decide about its sound competence without the need to have the ruling of the ordinary court. And it's obvious why, because in this way you are incentivizing the use of the arbitration, because if you had to wait for the decision of a normal court, then you will enter again in the loop of never-ending processes. Then, of course, there is the obligation, as in any arbitration, for the arbitrators to be neutral, to be a third party, to be super partes, and to disclose whenever there is any conflict of interest. And there is also the other interesting principle of the separability of the arbitration agreements. What does it mean? If there is, and there must be an arbitration clause, as we said, to trigger an arbitration, this arbitration clause will be living per se, so will be consistent per se, and will be even, let's say, surviving the same duration of the agreement. Of course, the arbitration body can render interim measures, and it's also true that whenever there is an arbitration agreement, so there is a contract stating that the parties will submit any litigation to an arbitration. Of course, again, it must be a well-written clause, because sometimes we find some exotic clause that do not defer to an arbitration body on exclusive basis the dispute, and then if the wording is unclear, of course, there is room to go for the ordinary jurisdiction. But if the clause is well written, the arbitration body will be the only one that will have the competence to solve a certain dispute on a certain agreement. Of course, there are potential issues. So again, the same thing that we saw for the mediation. Whenever there is the public policy implied, there is a public government, of course arbitration won't work. You perhaps may have learned from the newspapers that the Kirchner government tried to, and actually did, froze all the assets of Repsol, that is the equivalent, I don't know, of British Petroleum, so the biggest petroleum company in Spain, that made a huge investment in Argentina. They froze the asset and they just kicked out all the management of the Spanish company suddenly, without any indemnification from one day to another. Then the parties enter into a mediation process led at very high level, but not into a formal arbitration process, just because of what we were saying before. Then, of course, it's also true that the Argentinian legislator wanted to give power to the arbitration body, in the sense that the arbitration award cannot be challenged in the merit, but can be challenged, and this is a waiver that cannot be granted from any constitutional right, and also in Argentina there is the constitutional right of any individual to act before a court to protect his fundamental rights. Whenever there is really a basic violation in the award of the fundamental rights, or whenever is needed a clarification. But if the parties, once have agreed on an arbitration clause, are not satisfied of the merit of the award, it cannot be challenged in front of the ordinary court. The same applies, almost the same, I would say, for Brazilian reality. We said before what is the very long timing to really get the result of the litigation, and so the Brazilian legislator wanted to find some suitable solution to this endemic slowness of the judicial proceeding. And so there's been a new code of civil procedures that has been approved just last March the 17th. And there is a strong push to have alternative dispute mechanism in order, as we said, to cut down the enormous cost of the litigation and to try to find a comparable solution, but with a more faster track. And what the Brazilian have done has been to create some centers that have been allocated into the tribunals to have the possibility to resolve in a professional manner and in a consensuated manner, so by means of conciliation and mediation, the conflicts. And of course, there is also a very good mediation law that has been approved just at the end of last year. So, according to which mediation is possible, of course, as far as private interests are at stake, but also provides, on the contrary of the Argentina, that mediation with public bodies and emanation is possible in certain fields. For instance, you cannot mediate or you cannot make settlement regarding the fiscal matters, so you have to go until the end of the litigation. Of course, also in the Brazilian case, the arbitration clause will trigger, and the mediation clause will do the same, a process that once it has been initiated and agreed between the parties will end with a binding resolution that will be binding the parties without any possibility to challenge it. And of course, it is also true that the more important law firms are also smelling the business of the alternative dispute resolution. So there are more and more mediation centers and arbitration centers that have been growing up in the recent past in Brazil. Of course, also here the law is too recent to see what will be the effect, but of course that's for sure, given also the big movement in the Brazilian policy, and given the fact that this slowness in taking a decision in front of a court is creating the side effect that many of the investment, especially for the public works, have been slowed down. We expect that the more will be effective this alternative way to face a dispute, the more the foreign investor will come to invest again in the country. So you can see here it's impressive just in the higher part of the chart. What has been let's say the trend? We came. It was just a little bit more than 15 years ago. The arbitration was really almost a non-word in Brazil. Nobody went to arbitration. There weren't a reliable institution to lead an arbitration. Then once in 2001, the Supreme Federal Court ruled that the Brazilian arbitration law was constitutional and also changed the homologation power, so that now to enforce a foreign arbitral award takes between 1 year and a half and 2 years, which is like a paradise in respect to the 10 years average or 7 to 10 years average of a first degree litigation in front of the civil court. And so the power has been transferred from the Supreme Federal Court to the Superior Court of Justice. This has pushed much more the parties to go to arbitration. So it's really impressive. You can see that Brazil became the third largest user of the ICC arbitration. So that, as you know, the International Chamber of Commerce rules are the most used one around the world. So it became the third country with a plus 500% of arbitration between 2005 and 2013, and with a plus 1,000% of the value involved in the same period. So, of course, there are good things and there are things that must be a little bit fine-tuned. But what is true is that the regulation as it is now reflects the best pro-arbitration jurisprudence, not only at Brazilian level, but I would say at international level. And of course, there have been eliminated a list of mistakes or unclear provision in the past that prevented, in some cases, to make recourse to the arbitration. And in this case, also there is an explicit authorization of the Brazilian government whenever it's see that there is a sort of principle of right of the other party, of the private company, to start arbitration procedures. Because at the end, if you think about it, the way it works in many countries, the state, the government, I'm also talking about Italy and about the fiscal procedure there, the way, and this is why also Italy has been condemned by the European Court of Justice because of the endemic slowness of the issuing of the judgment. Whenever you force a citizen to go through a painful and never-ending litigation, you are denying a basic right, because at the end you will force the citizen, you will force the company to accept whatever kind of compromise or whatever kind of decision taken at the administrative level, because you will be at the end entering into a never-ending loop, spending a lot of money, and to see the result of this long fight in front of a tribunal after 10 years, and after probably when your company has disappeared. Regarding Chile, it is, let's say, so I've just taken the example of the main fast-growing countries in LATAM. Chile is an example of a fast-growing country with, let's say, institutions that are very similar to the West European one, but for which the mediation is not, for instance, very used, and the legislation is perhaps the oldest one if compared to the other countries. Here, of course, it's true that the methods of alternative dispute resolution are binding, and that even the settlement agreements do not need a formal stamp by the court. But it's true that the modern principles about competence, or about the severability of the arbitration agreements aren't yet there. So it's still there's still something to do. And you can see here you have this basic two kind of arbitration. One is a domestic commercial one, so the law is very old, so we are talking about a law of more than 1 century ago, the Code of Civil Procedure, but even the one that is the organic code of judiciary is not that recent. While it's quite different regarding the international commercial arbitration, because here we have more recent regulation that has been created during the past 15 years, and we have also an arbitration and mediation center that is very effective. And here we have, of course, all the, let's say, the summa of the principles that are typical of any arbitration. So parties' autonomy, procedural flexibility, and intervention of the court that is limited really at the minimum extent possible. And again, an international arbitration award can be opposed not for merit reason, but just if there is a petition of nullity, again, because there is a fundamental violation of basic rights. Now we go to the fourth and last country that I analyzed, which is Colombia. In Colombia, Colombia has been discounting in the past a very unstable political regime. They had a guerrilla problem. Now Colombia is back to growth, thanks also to the even biggest political troubles of other countries such as Venezuela or Cuba. And in Colombia, I must say, I have been there recently. There is a lot of initiatives about new tendencies in terms of law, and the result has been that there's been a new law about conciliation that has entered into force in 2001. The conciliation regulation is one of the most advanced and sophisticated, as I said. And the only thing is that to be a conciliator, on the contrary of many other countries where the conciliation is considered rather an informal process that can be run by everyone, of course it's important that both or all the parties that are involved in this conciliation proceeding are agreeing on the name of a conciliator. There it must be a lawyer. But of course, the let's say good side of the medal is that There are also for small conciliation, for small size matters, the public government put at disposal some conciliators for free or almost for free, allowing also to the people that do not have big means to go and refer to a conciliator. While there are chambers of commerce that do and practice conciliation at the highest level for the more important dispute at stake. And you can see that there is a nice settlement rate. So whenever the parties decide to go and conciliate, there is a nice chance. So it's more than 2/3, I would say 3/4 of the disputes are solved at conciliation level. Then, as we saw for Chile, we also have a big difference between the domestic arbitration and international arbitration. Both are provided by a quite recent law that has been entered into force in October 2012, that is called Ley de Arbitraje Nacional e Internacional, with, let's say, again, it's a modern legislation taking into account the more modern tendencies. And here, the international arbitration is more flexible because you don't have to be a Colombian citizen, or you don't have to be a lawyer, or you don't have to be subject to the limit of the five arbitration if you are part of an international arbitration body. Like in Argentina, you have the prohibition of the public entities to use internal law in order to avoid the obligation imposed by an arbitration agreement. But then you also have on top of it interesting things such as electronic notification, which, as you know, are not common practice in all the jurisdiction, and the arbitration bodies can also execute a provisional measure by means of the foreign acknowledgement by the local tribunal of the award that has been issued abroad. And if none of the parties are Colombian, the award rendered by an international arbitration tribunal with cities in Colombia will be considered the same level of a national award, so with the same prerogatives, with the same absolutely level. So, and again, as we saw in the other parties, the national recognition procedure shall be used to execute the award. So there is a principle of trust that we see also in the other countries in the foreign jurisdiction. So whenever there is also an arbitration award that has been born outside the country, there will be all the effort made by the local tribunal to render it absolutely enforceable, so that there is no excuse for the parties to comply with this arbitration award. So that's all from my side, and if you have any questions, please feel free.
Thank you for the presentation.